they have created a liability, right? They've created a charge, right? They want to charge you. They want to charge your account. That's what they want to do. They want to charge
Right.
your account. They already opened the account, right? You have a case number, right?
Yes.
So the case number is the account number. So there's already an account. And remember, in a bank, what do you need to give them for them to open an account? You need to give
My
them something,
information.
right? Yeah, you
Yep.
need to give them information. Yeah, you need to give them information. You give them. They ask you for your social security. They ask you for these things here, but also they usually a bank would say, "Hey, well, you open an account, you got to give us like $100 or $50 or some type of money, some type of funds, right?"
Right.
So that usually is what is added into the account. So they don't just open an account and it's at zero. So they want you to put something in there, right? So what they're doing is that they already opened an account and now they want to charge it. What does charge mean though? Right? So this is the thing is that when we read the acceptance for value, right? In
Yep.
that it actually explains to us, that the charges are basically credits. They want to give us credits. So that's why it is completely okay for you to say, yeah, man, I accept those charges. I'm here to accept the charges on behalf of, behalf of the principal, on behalf of the debtor, on behalf of the defendant. I'm here to accept the charges. Because remember, you're going in there as a third party, right? That you're not the defendant, right? So you're going there as a third
Yes,
party.
indeed.
And you, the third party, have an interest in the business that is occurring right there, because the court case is administrating business. They're administrating something to do with an asset or an account of somebody, right? That they're administrating it. So remember how it all starts. It starts with the officer bringing the charges, right? So the officer once already put the charges in there, but now they need somebody to be a surety. So they got us there in court as a surety. Now it's on us. What we want to do? Are we going to accept the charges? Are we going to deny the charges? What do we want to do? But it's actually it's a dishonor to deny the charges, but we can avoid the charges or accept it. But if we deny it, then it's a dishonor. It's like we're fighting with them. So we can, like I'm saying, is that what we want to do
And
is
that
we want
brings
to,
us into their jurisdiction
well, when you
because
say
we're
their
acting
jurisdiction,
dishonorable.
yeah, well, the thing is that it's commerce. It's commerce. We're in commercial jurisdiction, but you're going in there as a third party. So remember what is happening too. Another thing, that's why we're going to read this, the trust, the secret trust, because everything has to do with a trust. So the charges that they're bringing forth, this is something that they're doing within the public trust, right? It's happening within the public trust. They have all the rights as trustees to manage and administrate the business and affairs of the public trust. That's why they can legally do that. And there's a presumption that you are part of that public trust in a certain capacity, right? That's the presumption.
Right.
So when you go in there, you're going to clear that up. That's your intent, right? Your intention is to clear up that misunderstanding or that assumption, but also to affirm that you're not there to to basically be at war with them. You're there to help them out because you are a creditor. You're there to give them credits. You're there to provide them with the credits if that's what they need. You're there to provide them with an asset. And the only asset that you can really give them is that of your trust. Correct? So
Right.
if you have a private trust and you're the trustee of that private trust, you now have authorization to manage and administrate that trust's business and assets. So you can actually issue out money from your trust and issue it to their trust, which is a public trust. So that whole process is basically you providing them with a financial asset called a bill of exchange or a promissory note. A bill of exchange is what basically you can utilize with the charges that they're bringing. So remember, the charges is on the defendant, on that legal entity. So they say they want to charge that legal entity. They want to give that legal entity credits. That's what they want to do. But who's going to provide the negotiable instrument or the bond which will provide those credits? So then that's when you come in and say you'll provide it. Your trust will provide that. You're going to provide the credits for that uh, public person, that
Transaction.
defendant. Yeah, and you're going to provide it by your um, by issuing your bill of exchange. But you're going to do it the right way. You're going to say, you know what? I want to provide this, but this has to be paid to the order of the treasury because I want to make sure that the asset that I'm taking from my private trust is going to the public trust, but it is being accounted for. So the ones who are in charge of that accountability is the treasury and the tax department, which they're doing business as, right? So those two are the main ones. So you want to make sure that you pay to the order of the treasury. For what reason? What, now that they get and receive this asset, they receive the bill of exchange, that's going to be added as a credit onto the public trust. So now they have a credit. Now they say, wow, okay, what do you want us to do with this credit? Thank you very much for this credit. We say, well, yeah, I would like that credit to go to this account right here so that it can discharge an obligation and it could set off the account, which is your case number, right? Do you
Now,
understand
does
how that
that make
goes?
me, yes, indeed, does that make me the drawer on that bond or the drawee?
Well, wait a minute. You're talking
The
about the bill
bond
of
that they
exchange?
have. Yep.
Well, if they're issuing a bond, right? If they issue a bond, let's say they issue a performance bond or whatever, and it has the name of that legal person that you have rights and interest to, you can claim it in a way to where you can control it. And how do you do that is accepting it. Say, I want to accept all bonds. I want to
And
accept it,
return.
and now that now that you have the bonds, because you have an interest in it, you basically have, it has the legal, anything that bears your legal name, and if that legal name is part of your private trust, now that is property of your trust. So now your trust can come in and say, hey, this instrument right here has trust property on it. I'm going to claim this. And this is a bond. Okay, so now this bond I'm claiming it, and I want you to utilize this. I want you to utilize it. So then that's what you can then take that bond and assign it over to them. And just, and that's when you say, hey, I am the bond holder, and I want this bond to be used to discharge the liabilities. And if that's not enough, I will give you another bond. That's why you come in with another bond, with your own bond, because a lot of times their bond might not be enough, right? So they produce another bond and they'll produce another bond. You come in and you just give them a bond, right? You give them a bond. Uh, and remember, every bond, it has to be securitized though. It needs some type of something that will secure it, right? So that's why when Eric says, okay, then you give your birth certificate, right? Well, the birth certificate contains the account number, right? So you're basically giving them an account number that's going to be the collateral that will secure the obligation, which is the bond, right? So you
Yep.
have to give them both. And then you tell them use it for this and this and this. And by the way, I've already went forward and helped you guys out. I'm reporting this to the tax. I'm giving you a copy of the 1099A, the 1099 OID, which is the outstanding issue discount. And you, there's another form called it's I believe it's 8281. Let me see if it's that.
Um,
8281.
I was also
Tax.
informed we could fill out the 1040 ES, which is 1040 estimate on, and that way you can receive the funds back within a few months. It's an estimated for the
I'm not.
following year taxes. That's what Eric
Oh, okay.
informed me
I'm
of.
not sure about that one. I'm not. Maybe. Yeah. If he has some knowledge about that, that's great. I'm not sure about that one. I'm not sure about that. But the 8291, I believe it's 8291. I have to look it up again. You know who speaks highly of this? It would be Gene Keating. He speaks a lot about this because it
Okay.
actually I don't know if 8281 or let me see.
Is it
I
is
have
it
to
on
look
that
that up.
other video? Is it on that other video? The
It is
4 hour
on the
video?
other video with brother Yahashua. Yeah, he talks about it too because it actually outlines who the issuer is of the bond that you're producing. If you're
Okay.
the issuer, you're the original issue, you're the issuer, then the OID will validate it, right? And then that basically what you're doing is uh, again, when you say discount, what you're meaning is that you have taken a promissory note, right? And you have sold it, you have transferred it, somebody has purchased it from you, right? And a purchase,
Right.
the definition of purchase is an acquisition. Somebody has acquired that as trust property. So somebody acquired money or currency in the form of an asset into the public trust. Somebody in the public has acquired it, but that came from a private trust. So you want to make sure that you report it because you don't want to wait for them to report it. You want to report it so that the tax department, the treasury department are aware that new money came into the public trust. It was your asset. Your asset went from private into public, and now you're going to report, hey, new money came into the public trust. That's an income. The definition of income is money going into a trust. So because you deposit or you transferred or you made a sale, you made a discount, right? Some public person received it. Now that's an original issue discount. So you're reporting the OID on it. But I don't think the OID means, yeah, I think it's original issue discount or
Yep.
outstanding issue discount.
I have it as original, is what I've seen it as.
Yeah, yeah. But some people have mentioned that it's an outstanding, right? Because it's still there. It's
Right.
because you want it back, right? You're because they're just borrowing it because then you're gonna fill out the 1099A, and in the 1099A it says you're the lender, they're the borrower, right? So they're
Yep.
borrowing a note, they're borrowing a bond, they're borrowing an asset, right? And now they get to use it. That's fine. They get to use it, but then they got to return it back with a little bit of interest. That's how it works in commerce. So that interest, we take that and we give it to the tax so that the tax department can use that and go collect the principal amount for us, right? Because they need a little something too. We're the ones who provides them with the credit. They don't have anything. They're broke. They're they're bankrupt, right? And so is all commercial entities right now. And one of the interesting things, like I said, is that the way that the system works today is that everybody is in commercial is doing commerce, but they're broke and they need to be funded somehow, some way. And the only way you can get funded is to find a manner to exchange something for credits, because you need credits in order to play the game, right? So what they accept in this system as credits is a promissory note. They accept it as credits or an order to pay, but the order of pay have to be attached to a source document, right? It has to be attached to a source document because so now let's say we receive a utility bill. The utility bill is showing the account number. It's showing that there is a credit due on the account. It shows the title of the the legal person who is on the account as beneficiary. It shows all that. So that right there is what you're going to take and convert it into an order to pay. And the source document, the account, is the collateral. So you're converting that instrument, that piece of paper, into a negotiable instrument, but a negotiable instrument also needs to have some backing. Something has to back it up, something has to secure it. All right. So the source document, which is the account, that's the collateral, right? So you can utilize that as an order to pay. And at first, I remember, to me, this whole trust thing is so important because if we're operating under the prison, or if it's presumed that we're operating from within the public trust as a public trustee or a public beneficiary, either way, we don't have that much control of the assets. We have to come from a third party, a private trust, and we have to be an officer or some holding some entitlement in that trust in order for us to be able to say, hey, I have the rights to manage the trust assets how I wish, as if I was the owner. I have that right, but I'm doing it for the benefit of the private beneficiaries, heirs, and successors, for all the qualified heirs. Because in the public trust, if you look the public trust, there we have there's the Constitution. In the public trust, the trustees have certain powers, certain duties, certain obligations. Their obligation is to the beneficiaries, and the beneficiaries are all minors. Minors cannot delegate property. They cannot deal with assets. They cannot be trusted with these things because they're minors. That's why there's trustees to do these delegations or these administrations, right? So if we're coming from the private, if we're coming from, sorry, from the public trust, being presumed that we're a trustee of the public trust or presumed that we're a beneficiary, but regardless, we don't have standing really per se in coming from a public trust to do much. We're only there as accepting benefits and dealing with that. Now, obviously, if we come in from a private trust, then that's different. But we have to make sure that it is completely understood, and we rebut any presumptions that we're in the public, we're coming from the public uh, platform. So I think this manual right here that we're gonna read right now is gonna be very. Oh man, Archie's here today. Shucks, I forgot I had to.
Enter people in.
Yeah, well, I forgot. I didn't know Archie was gonna come in, but that's cool, man. I'm happy Archie made it. Hey, what's up, Archie?
Yeah, what up, bro? I'm just getting off work, man.
Yo,
Man,
man, I'm happy you made it, bro. Cool.
yeah,
Hey,
I'm at,
Ernesto. Good,
I'm
good
in
to see you
traffic
guys,
right
man.
now.
Oh,
I'm
snap.
going ahead to get my hair get done, man.
Oh man, hell yeah. Yeah, yeah, man. That's cool, man. I'm glad you tuned in. Yeah,
Man,
man, my
I'm.
apologies, man. I've been so busy I couldn't get back to you, man. I'm so busy, man.
Oh, no problem, bro. I appreciate it, man. Man, I always forget her name, bro. Man, we be talking
Lorna,
and Lerna,
Lorna.
yes, bro. Man, she makes some big moves, bro.
Oh
You
yeah,
said
I
about
gotta.
that ticket, bro.
Yeah.
Bro. That's crazy,
Where is
man.
Lorna, man? She got a discharge. I mean, she got a
Yeah,
dismissal.
yeah, she got that's basically a discharge. Yeah, a ticket discharge,
Yeah.
bro. When
Oh,
she
she
said me that,
was.
I'm like,
Oh,
alright,
she's
this is
just joining
really.
in. She's joining in right now. There you go. See, we're talking about her.
Hi
She's gonna live
guys.
forever, man.
Yeah,
Hey,
I was
Lerna,
trying to
we
get in
talking about you,
earlier.
man. Nothing bad though. It's not bad. It's all good.
Yeah, yeah.
We
Oh
talking
yeah.
about we talking about that big dismissal.
Oh
Hell
yeah,
yeah.
for sure, for sure. That was amazing, man. It feels good. It feels good to get
Yeah.
remedy, you know.
Yeah, man. You want to share with the rest of what happened right here? Because Seth's here, Ernesto's here, and obviously the public, whoever's gonna watch the video.
And
Okay.
congratulations to you, young lady.
Thank you. Thank you. Appreciated, much appreciated. So what happened is I got a parking ticket like 3 weeks ago, and I took the ticket and I returned it. I wrote on the face and I returned it to the citation for California, and they sent me a letter last week, Thursday, and they said that they are reviewing my claim, and that they would mail me and let me know what's next. And yesterday, it was yesterday or day before yesterday, I received the letter, and they said that they made an error after they reviewed it, that they made an error, and there was nothing else I needed to do, and the ticket was canceled.
Yeah, dismissed. It
It was
actually says
dismissed.
dismissed. Yeah,
Yes.
that
Mister.
was beautiful.
Yeah.
That was
Zero
beautiful.
out.
Yeah.
Zeroed out.
Yeah.
What's up,
That was sweet.
everybody?
Hey,
Hi.
what's up?
What's up? What's up, guys? What's up, family? God bless.
Yeah, yeah.
Hi.
Nice to see you.
We
Nice to
ready?
have you guys.
We ready?
Yeah, you heard Lerna. She got her little dismissal, man. That's cool, man.
That is so awesome.
Hey,
Yes, it
sheesh,
feels
man.
great.
See, Chad, they
Imagine.
recognize it all here, Chad. They recognize it all
Yeah.
here. They know what's going on. You know what I'm saying?
Yeah, they
Yeah.
know, man. They know what's happening. But you guys have it good in the States, right there, because
Way
I
easy.
think
Yeah.
it's a little bit. I think because it's already been. You know how much people have been challenging this in the States, man. So long, people just listen to Gene Keating. He's been doing this for 50 years. Think about that, man. That's wild. So I'm very happy about that, man. So what we're gonna do is we're gonna dive into this thing right here, the secret trust, because what we're dealing with right now is we're dealing obviously with trustees, with public officers, public trustees. So obviously, the whole public is a trust. It's obvious, right? And what we want to do eventually is we want to separate ourselves from uh, that association, and we want to make sure that our allegiance is to the private trust, and we want to come in as a third party all the time. In that way, we can manage the trust assets instead of having the public trustees do that for us, right? Or the public trustees has us as a public trustee also, and now we are regulated under them. But if we're coming from a private trust, right, we now have authority to administrate property, which they're trying to administrate. Obviously, they can't administrate it unless they're a qualified heir. But you're a qualified heir, right? You're the one who has all rights, title, and interest in your legal name, in your legal person, and anything that it's created, right? Which is all those little instruments, those commercial instruments. So
Equity.
yeah, man. Exactly. So did you guys all get this document right here? You guys all have it?
No, I don't think I got it.
I'm gonna send it to you then, Archie, in a little while. You want me to? I'll send it to you in a little while so you can have it too. But I think
I
Seth
don't.
has it. Lerna, you got it?
I don't think I have it either.
Oh, you don't have it? I'm gonna send it to you then.
No.
All right. It's a good little it's not that much. It's what? Let me look at. I think it's 52 pages.
51 pages.
hmm So
Uh,
see, it's right
what
here.
did you
It's
write
this.
on the parking ticket by chance?
You want to share that,
Wait.
Lorna?
Oh, what did I do on the parking ticket?
Yes.
I actually let me go and look at it right quick. I wrote on the face
Because I have some traffic
so
tickets. I was told to get the case number for it and file my paperwork under the case number for them.
okay, so what I did because what I did the 72 hours and I just resent. Basically,
She
get it
rescinded.
in 7 So when I sent the ticket, I said refuse for cause, timely without dishonor. I said and without recourse to me. And I said I I do not accept I do not accept this contract.
Yeah.
Uh, yeah, and then what I did also what I did I can I think you have it. You can share it with them.
L- Yeah, let me see if I could pull it up right here really quick. But what she did was she actually put her
Cover
seal. She put her trust seal on it too.
Yeah,
Yeah, the show seal. Yeah, that make it way more official, so they know that you have a trust out there. So basically, they didn't want to challenge that trust because they already know that whatever
It's not their
presumptions
jurisdiction.
they gonna make, that like they can't go against that.
Yeah, it's not their jurisdiction. Let me see if I can.
Yeah,
I have to
they're not
send
even
it. Let
gonna
me
they're
see.
not even gonna waste their time for that.
Yeah, I haven't had
Um,
a consent meet up yet though, but I do have a certificate of trust, so that I'll be filing with it.
yeah, that certificate of trust is good to have, man. Definitely. And if you can get it recorded, even better. That'll
He informed me
shucks.
since I had it notarized. It is already by this day.
Yeah, that could work too, because
So
I do have mine recorded with the notary. I never did like send mine to the clerk, but I'm in the process of doing that too. That with my citizenship with the authentication on it.
Hmm.
nice.
Well,
Yeah. So I
I'm gonna
have
see if I could
mine.
share.
I got mine authenticated since 2001, but I didn't know what to do with it until I start back to learning and get back into the studying and stuff like that, and then that's I'm starting to get back on track because there's a lot of stuff I actually got done because I end up got my EIN for my estate and I have my EIN for my trust. Well, I actually that's the EIN I'm using for all accounts. I removed my social from all different accounts from like purchasing, like for example, like getting a car, light bill, phone bill. I don't use my social no more.
Very nice.
All right.
Yeah, I removed my phone bill, all that. My phone bill used to be 120. I'm paying like $20 a month for my phone.
Let me see. I'm gonna try to pull that for you. What Lerna has right there. What she sent me.
Make sure
She
you
gave
cover
me
up
the.
her personal information though, since it is going out in the public.
Yeah. Well. Yeah. She don't really have that much personal things on there. She just wrote what she
It's,
wrote,
it's
and
just like she just wrote up. It was all in like red ink, and she did it good too because the way she put it in ring it, that's like a cease and desist. Anything in red, writing back, that's a cease and desist. Don't call, don't disturb me, don't send me anything. So she sent them that's actually a cease and desist right there, writing in red.
yeah.
That's a cease and desist, letting you know, hey, you can't, you
See
can't.
that's it
It's out
right
of your
there.
jurisdiction, pretty much. Yeah.
I don't know if you guys can see that, but that's it right there. See. Uh, So I guess you guys are
Okay,
gonna have to just.
so like for everybody watching, I think you guys can actually like on your phone, or if you're on your phone, you can open the screen and it's gonna open and you can see what's on there.
Yeah.
Yeah, it
Yeah.
zoomed in.
Yeah. Hmm. So that's basically, and see, she put a little stamp there, a little seal, right? She's not messing around. She let them know straight up.
Yeah,
Yeah,
man.
this
I'm
is
just,
trust
like,
property.
yeah, it's like you just get tired of these people. Like, you just park your car on the side of the street. If it's like 1 minute and you come back, there's somebody already there to give you a ticket. So it's just, it's disturbing to deal with them out here. So now we gotta, we gotta figure out how we gonna, discharge these debts.
Yeah, definitely, man, definitely. And like I was talking to Seth earlier, is that we actually have different options in how to deal with these things here, because what those tickets are too, if it's properly endorsed, you could convert it into an order to pay. And if you know how to file the taxes really good, then you can get that back. Whatever, you know what I mean? You can convert that into an order to pay, because what they're having us sign are these different charges. And well, a charge requires a bond in order for the credits to be generated, and therefore we can control all that. We actually have the capacity to control. Well, we can have the capacity to control all that. It all depends on how much we know. So
Yeah.
we can refuse for cause, or we can accept. I do a banker's acceptance, and then just pass on
Yeah.
the liability, so that the other individual, the other party, becomes liable to pay, right? Because what we're doing is we're passing down liabilities. That's what we're doing, right?
Yeah.
We could either keep the liability or pass it down, like how Brother Yahashua was saying. Just it's like a hot potato. We gotta That was a good video, man. I really enjoyed that video from Brother Yahashua. Um, I really like that one. He set it down pretty good. But check this out. What we're gonna do is let's get into the trust document now. This right here, the secret trust. We're probably not gonna finish everything, but I'm pretty sure you guys are gonna like the information that it has. I read it once already and I really liked it, but I'm pretty sure that reading again, I'm gonna learn a lot more. And it looks like Seth came out. He dropped off, so I'm gonna see if he comes back in. But let me start to read, if it's okay with you guys. It's the Secret Trust and Forms Manual by D. Wiesen, one of those. And let's see, preface about the author. I'd sure like to read this. See, it says here about the author. This treatise was advanced by tax and estate planning attorneys and CPAs, now with big six accounting firms. Each has many international clients. This manual's project manager, author, has specialized in taxation and estate planning for 36 years at the international level. Some have contributed in many ways to several United States congressional committees, ranging from legislative judicial reform to international income tax treaty reform. Why this manual was written? Well, the productive backbone of America has been broken by diabolical forces which now control the most powerful of the world's government. This has been accomplished by coordinating the creation of laws beneficial to these forces at the expense of modern day entrepreneur. This minefield of legislation has been designed to create a golden way for the megalomaniacal few who are its sponsors, while preventing the efficient many from benefiting from the freedom that was once the province of all. The result limits potential competition for the established few and prevents a level playing field for a free market. If we continue to allow the status quo, our efforts to lead a better, more secure, and prosperous life will continue to be frustrated by even more onerous taxation and growth prohibiting laws. This course will surely lead to financial and political doom for almost all in America. Evidence of this change already envelops us. Since the time has not yet come. Hold on, guys. Let me see if Seth is trying to come back in. Yeah, he is. Let me put him in. There you go. I think he is in. Yeah, he's
Thank
in.
you, brother.
Perfect.
Yeah, booted me out.
Yeah, no problem. Yeah, no problem. No problem. Since the time has not yet come when the revolutionary ideas of the founding fathers are about to be revealed, we The authors are giving you a personal road to follow, which will allow you the same legal advantages that those who have created this quagmire of law now possess and use. This solution is now enthusiastically being given as a means of survival and growth in the hopes that soon the responsible people of America will be motivated to seek those original freedoms that were once theirs. There is no excuse for not doing something, even as you now read. The price for not restoring your freedom will not only be paid directly by you today, but also by your families and their families yet to come. Even if people act, there will be a sudden powerful surge in national wealth building at the expense of really no one who matters. The losers will be those who are opposed to competition, and surely they are our enemy and the enemy of America. The guided path that we will point out in all necessary detail can be executed by any layman who so desires. But for those that feel they would prefer a ready to operate system already in existence, we will show you how to plug into a proven and reliable operation for immediate use. Because the laws prevent both attorneys and CPAs from assisting you in the formation and or management of any trust operation you may wish to set up for yourself, Grantor Trust Rules, page 17, the authors has further tried to help you with this problem by using a nom de plume of the Wizen. This law is a bit ridiculous, but it is the law. That's true. They don't like giving legal advice. Trust. According to the dictionary, Black Law 6th edition and Third Encyclopedia, Corpus Juris Secundum, legal forms. Okay, it's basically just. Okay, let me go up right here. Okay, the above list is a handy guide when looking at the forms that are included in this manual. So I'm guessing this is the list that he's talking about right here, this list right here. The above list is a handy guide when looking at the forms that are included in this manual. Please notice that we have tried to reduce a number of legal citations in this treatise. This guidebook could easily have been expanded into 20 tome reference work. In creating this manual, the most difficult task was to cut out almost 90% of our original manuscript so that the ideas we believed you would need and use could be as uncomplicated and clear as we could make them without the need to have a reference library at your disposal. For further reading, please refer to CJS, where anything you might additionally need is thoroughly covered. Judge learned hand. Anyone may arrange his affairs that his taxes shall be as low as possible. He is not bound to choose that pattern which best pays the treasury. There is not even a patriotic duty to increase one's taxes. Over and over again, courts have said that there is nothing sinister in so arranging affairs as to keep taxes as low as possible. Everyone does it, rich and poor alike, and all do right. For nobody owes any public duty to pay more than the law demands. Taxes are an enforceable exaction and not a voluntary contribution. Forcible exaction, not a controversy. This is from right here, Helvering versus Gregory. History of trust. In order to understand and get a practical comfort zone from U.S. persons, for U.S. persons, we recommend starting with the Black Laws Dictionary 6th edition, third, and confirm the legal definition of trust as a right of property, real or personal, held by one party for the benefit of another. Or Barron's Dictionary, and we find that the New American Webster College Dictionary, 1981, gives a similar definition which may be more readily available to the reader. It says, a trust is an agreement by which management of property by one party, which is a trustee, for the benefit of another, a beneficiary, is given. Though Black's sixth refers to state laws, the international aspect of the composite trust form we show in this manual prohibits any state laws from interfering with this indenture, which is a contract. Both state statutory law and common law regarding professional trust companies and fiduciaries, trustees, do apply, but will not apply to you if you use the structures and forms we see working so well. After defining trust, we recommend going to the law library and studying trusts in a law encyclopedia such as the Corpus Juris Secundum. After this, all you need to become more familiar with is Trust is Good form book, such as West Legal Forms, AMJOUR, Pleading and Practice, or Moore's Form Manual. The first trusts were reported in the Roman Empire in the Emperor Justinian reign. Isn't that interesting? In the Justinian's reign. The Justinian Code, it's called, okay. Trust became a preferred method of property management in the Middle Ages on the European continent. They were prevalently used under English common law before corporations existed. Trust organizations arrived in America with the colonists, and the first account in the US was drafted by famous attorney Patrick Henry in 1765, 24 years before the adoption of the US Constitution. It was drawn up for Governor Robert Morris of Virginia, then a colony, and whose large trust wealth was used to help finance the American Revolution. You hear that? It's a trust wealth was used to finance the American Revolution. In Morris's trust, known as the North American Land Company, lands owned by Governor Morris were transferred to the trust, and records show the court's order, the deed, etc., transferring the lands. Even so, records of trusts are few, as their rights to privacy are protected and held inviolate by numerous court actions and by the U.S. Constitution itself, Article 1, Section 10, Paragraph 1, and by the 14th Amendment to the Constitution, Clause 1. The main reason we prefer trust to all other forms of asset protection and doing business is the hundreds of years of good law that have developed around trusts compared to the more recent innovations, i.e., corporations. Bank trustees, they are severely restricted by their own choice to limiting whatever degree of fiduciary responsibility they may or may not feel comfortable with. Such a position is truly adverse to heirs, which are beneficiaries, and often limits income and capital appreciation for the trust. Fees definitely cut into what can easily be diminishing assets and income. Over time, the trustee ends up with the money and the heirs are left abandoned. It is like a poker game where a dealer cuts each pot by, say, 2%. After 50 pots, the dealer has the whole pot. You can act as trustee. You can serve without fees if you so choose. This alone is the best reason not to use the third party trustee. No one has a better interest in your estate than you do. Some excellent offshore trust companies have been in business for almost 200 years, earning 20 to 30% per year tax free for their beneficiaries. These we recommend as successor trustees. Don't ask lawyers or CPAs to find laws that offer loopholes. Attorneys are trained to know the law and how to research the law. So, yeah, okay. Another way for you to better understand the use of the word law, substitute the words you cannot do something, not what you can do. When this is fully understood and locked away for future reference, you probably will avoid most of the present problems that arise in using an attorney. In other words, most people are asking advice from lawyers that call for a positive course of action by the questionnaire. This mistake puts the lawyer in a bad position. They can only tell you that a certain course of action is illegal. All that is all that is not illegal or okay doesn't require a lawyer's advice. It is outside his purview. The IRS, SEC, FDA are in business to collect taxes and or restrain your entrepreneurship. These administrative laws and regulations are not written to show you loopholes. Lawyers and accountants only know what these laws state. If the course of action you choose is legal, you never have to prove it. The other side has to find a law that says that what you're doing is illegal. Again, if there are no laws that state that your actions are illegal, then automatically you are doing what is legal and you don't have to prove it. Really, it's not fair to ask most lawyers to give you advice about international trusts, tax havens, tax treaties, etc., for the above reasons, and as it most likely is outside their expertise. So, so we know now. Oh, Seth got kicked out again. Let me put him back in.
Thank you, brother. You hear me?
Yeah, got you. My bad. Is this
Beautiful.
when I'm
It's
reading
okay.
the yeah, when I'm reading it, I can't see who went off or who came back in, so I got to go back to
No
the
worries.
yeah.
It still
So
allows me
my
access
bad.
to hear you, though.
Oh, it does.
Yes.
Yeah,
So that
because
was
I
okay.
see Sabea, she's on, but I can't get her in. But I'm thinking she can hear everything, so I'm pretty sure she can. Now that you've confirmed that, great. Okay, let me continue reading. Okay, here it is. Legal citations. This manual was designed to give the highest quality, most succinct, and I'm not sure how that word is, and practical advice to the layman, non-attorney, that we could give without citing too many laws and court cases. As we attempt to take you along the winding path which will allow you to have equal footing with those very same organizations who created or caused the creation of impediments for the businessman. Now, for those who wish to see some important and more frequently discussed sites, we suggest a reading of Trusts in the Corpus Juris Secundum. This will give you all the law and all the citations you could ever need. Legal entities, the four forms of doing business, sometimes referred to as legal entities, are sole proprietorship, partnership, corporations, and trusts. Problems with partnership, sole proprietorships, and corporations. Problems to be overcome. Corporate personal taxes, dividend taxes on shareholders, bureaucratic red tapes, registration fees, DBA advertisements, renewal fees, registrations, agent fees, filing multitudinous forms with governmental agencies, stockholders and directors meetings, keeping minutes books, government required record keeping, contributing and maintaining minimum capital requirements to keep listing, and being subject to political scrutiny, etc. As you start using trust, you'll realize that you will totally avoid getting forced into buying risky tax shelters. You have a permanent tax shelter in the trust. You no longer will be induced to create fictitious and exaggerated expenses to offset income. If you are or are thinking about being an officer or director in a company, you will be free of the fear of being held personally responsible financially for your actions. Your present concern and possible worries about divorce, malpractice, bankruptcy, nuances, suits, and liens, and potential squabbles over your estate by your heirs will forever disappear when you fund a trust while you are still alive. Unfortunately, probate concerns will continue to agonize the unheeding many. Your retirement income can be accumulated and paid out tax free. As you read on, this will be better understood. And for those who are now employees, you can obtain a trust and develop a new business, manage parents copy manage patents copyrights, start a new career, lease property, or trade stocks and equities, etc. You can do all this and more privately with your own trust setup. Characteristics to pay strict attention to in order not to be classified as an association, a corporation, and taxed as a corporation. Purpose: the trust must be created and protected and conserved the trust must be created to protect and conserve property assets for the exclusive benefits of its beneficiary of beneficiaries. The trustee is not the beneficiary. Trustee is truly third party. The trust is not a business solely to make a profit, and the beneficiaries did not make any contributions to the corpus. Continuity. If the domestic trustee chooses not to serve, or if he dies, or if he is removed for good reason, the trust must be dissolved in the absence of a successor trustee. Centralized management. There can be no centralized management such as those receiving voting control from elect representatives. The trust is essentially a sole proprietorship where management is handled by one person, the trustee, because there are no other managers to do the management. There are no associates for whom management is provided. Associates. The trust has no owners. In other words, there are no parties of beneficial interest who have any management or voting authority, nor is there any party which can direct a change in the investment of the assets. That's interesting, huh? Associations. Transferability of interest. Beneficiaries do not have rights or authority to transfer any management or voting rights, as they have none to begin with. See, this is very important to understand. Beneficiaries don't have rights or authority to transfer any management or voting rights. Basically, they don't have any authority over the assets. So if at the beginning, I remember a lot of people were saying, just say you're the beneficiary, just say you're the beneficiary, just say you're the beneficiary. Well, as a beneficiary, and then, I remember starting this whole process, people were suggesting saying that you're a beneficiary and then accepting the charges and then delegating authority. But see, as beneficiaries, you just have limited authority, if any at all. So anyway, let's go back. Liability, limited liability. The trustee has fiduciary responsibilities for his actions as they affect the trust, and the trust indenture spells out said responsibilities. The beneficiaries have no liability since they never have any say in the management. You see what it says? The beneficiaries have no liabilities since they never have any say in the management. This is important to know. If any four or more of the above characteristics are deemed by the IRS to not be met by a trust, then the IRS will slap a corporate tax on the trust. By using the forms in this manual, you avoid all problems. Sham. Sham is a word that is battered around quite freely by attorneys and CPAs. The frequency of use seems to be an inverse function of their experience. The more experience, the less utterance. Rarely can a solid definition be obtained from those who use this word. So here's the definition in layman's language. For the purpose of trying to clarify complex law regarding trusts, account receivables, and international tax conventions, we will define sham as a word that classifies and refers to an agreement that lacks substance and or form. Form refers to the construction of the terms in the agreement, contract, indenture. Substance can be divided into two parts. Example, where parties to the agreement are truly third party and sit across the table from each other, so to speak, in an adversarial position, while setting prices that will be agreed upon as fair market prices or fair market value. The willing buyer, willing seller idea. All the arrangements and forms you see in this manual have been around for many years. We really are not getting off into unexplored territory here. Though some of these ideas you are now reading about may be new to you, we want to only stress here the tried and proven ways that we are comfortable with versus ideas with potential unwarranted risks. Let me just check, see if everybody's in. Yeah, well, looks like Seth is gone. Oh no, Seth's here, my bad. It's like Archie is gone. Okay. Trust safeguards. Privacy. Trusts are agreements, which are contracts, between parties. They must be third parties and are protected from any government, local, state, federal, interference by the Constitution of the US, which is the chain that binds the government from interfering in the rights of its citizens, who have retained these rights when they enumerated what the government can and cannot do. This powerful legal provision keeps the parties to a trust free from needing any permission from government. With trusts, privacy can be maintained, unlike other enfranchising forms of doing business. The purpose of the trust's operations must be to preserve, protect, and defend its assets for the beneficiary. Let me read that again. The purpose of the trust's operations must be to preserve, protect, and defend its asset for the beneficiaries. So when we go into court, because of some issue of a tax issue or some charges, where we're there for the purpose of defending or protecting or preserving assets for the beneficiary. That's what we're there for as trustees. Preservation may be encompassed income generation. Preservation may encompass income generation, which offsets the tendency of some assets to diminish in value over the years. Income Income generation is a secondary accomplishment for a trust. Hear that? Income generation is a secondary accomplishment for a trust and is not its main purpose. Tax avoidance falls into the same secondary classification as income generation. Assets, when the trustees so decides, can be sold and another assets purchased, all with its primary purpose in mind, which is the beneficiaries, right? When capital gains are generated, that also is ancillary to the trust prime purpose. The ability of a trust to be insulated from government restraints does have its limits. Fiduciary fiduciary propriety is mandatory, but that issue can only be brought up successfully by the beneficiary. If what appears to be improper to a party who is not a party to the contract, that alleged impropriety should be considered to be none of their business and protected by the supreme law of the land insofar as government interference is concerned. Especially true when that beneficiary is a foreign trust. But then the question must be asked, will you, as trustee, act in an improper way? Your answer is almost probably no. If all this sounds great, it is. Corporate trustee. By using a corporation as trustee, you gain the advantage of having you gain the advantage of having a perpetual trust. There are rollovers provisions in the same trust that we provide. This makes this type of trust doubly safe as far as this area of law is concerned. Bank trustee. About half the banks in this world use trusts of varied descriptions and purposes. The bank acts as fiduciary or trustee. Our personal experience with bank trustees since the 1930s is not very good because they mainly use what they call legal investments. This means that in their attempt to protect the trust assets, they lock in long range positions which continually, by the very nature of equities as an example, cycle up and down. They get caught in the down markets where a non bank trustee probably would get out of a down market and switch into cash or its equivalent until there is a reversal. There are plenty of other bank trustees' horror stories which could be told. But again, the purpose of this manual is to get you going in a wealth protecting and creative way. Part of the problem with the economy in the US is banks and the way they run their trust departments. Man, that's true. These operations provide a vast pool of capital that can be funneled into the coffers of corporate giants who can then further stifle competition. Foreign beneficiaries. A foreign beneficiary is the preferred way of operations today, and it should be well into the future. This choice gives even further insulation from possible governmental interference by placing the beneficiary outside the view of prying eyes with definite and powerful tax advantages. If there is a beneficial tax treaty between the foreign beneficiary's country and the domestic trust situs, which is the trustee, the trust can operate to its advantage in the US under those international conventions. For example, under the new tax treaty between Canada and the US, all ordinary income cannot be taxed more than the 15% that is required to be withheld by its US trustee, and sent to Philadelphia office of the IRS. Also, all capital gains, whether short or long term, are passed through under the treaty as taxable. This requires a simple trust. This is IRSC language, which means all income, ordinary or capital gain, must be passed through its beneficiary at least once a year. Instead of filing a 1040, etc., income tax form, the trustee obtains trust reporting forms from the IRS, such as Form 1041, etc. Whether or not any net income is earned by the trust, these forms must be filed by the trustee for each trust for which he is a trustee. The IRS will provide you with all necessary forms, tax treaty manuals in order for you to comply. See IRS Publication 597. Imagine now you can buy an unlimited number or value of assets in the US and enjoy zero taxation on 100% of all capital gains and on all ordinary income via the AR contract. There are pitfalls so arranged to prevent foreign or an ownership of US real estate and to force people involved with its sale, brokers, even buyers, to withhold tax on the sales price, plus other problems with the failure to report the original purchase to the State Department using a special information return with which few people are even aware. We mention all this so that you get around these rules by having a US person with US office sites take title to all property in the trust and still have all the advantages of using a foreign beneficiary. Sales should be made of your home as well to your trust. Okay, sales should be made of your home as well to your trust as one of the first things you do after setting up a trust. So they're recommending to sell your property, your home, to your trust. Transfer taxes can be minimized or eliminated by indicating on the transfer papers that the consideration for the transfer is love and affection. That's funny. It is best to do it right when it comes to such an important matter, not only for you now, but for your heirs later. There is not one way the foreign beneficiary, foreign creator, or foreign trustee can take one penny from you or your US trust. The average person who hears he has a foreign trust as a beneficiary immediately thinks he could lose everything. This is far from reality. Also, the idea of not owning things has been known to throw some people into a state of suspended animation. You must carefully examine how the form works. They are all in this manual starting with page 69. Ask yourself questions such as, where does all the paperwork stay? Who holds the notes? Can I buy back assets that I've sold into the US trust with paper, or do I have to pay cash? Exactly how can foreigners come here and steal assets from a US trust? Is the holder of the trust is the holder of the US trust paid out, bonded, fraud audited? Is the Cayman Islands government, the UK, honorable? Why are all the largest banks in the world quartered here? We hope that the answers will come to you in a comforting and reassuring way as we progress through this manual. All the parts will come together, somewhat like a jigsaw puzzle does. Problems with attorneys and CPAs. Every lawyer and every CPA knows that they cannot legally create or aid in creating a trust for anybody without violating a law. Ethics don't apply, so it seems, to some few professionals when it comes to their pockets. Since they don't wish to be sued for malpractice or run afoul of the IRS, they will come up with a thousands and one reasons not to proffer advice, not to provide advice about trust unless a trust company or other state law controlled fiduciary is involved. They cannot even talk about the trust. If you wish to be the trustee, as it could be construed that you were in the creator, sorry, let me read that again. They cannot even talk about a trust. If you wish to be the trustee, as it could be construed that you were the creator by agent for you attorney, the trust and trustee. You may even hear it say, you may even hear it said, as we have, that you are not truly qualified to handle your own affairs while you live if you want to create an inter vivos trust, and that such things should be left to the professional trustees now while that you are alive, for a very small fee, of course. And most definitely, another trustee bank should be brought aboard upon your debt for much the same reasons. Contradictory, isn't it, that a man who has created his estate would not be as capable of handling it and his desires as a stranger would be. We haven't seen any problems over the years with an individual handling his assets as trustee for a domestic US trust. The trustees successor trustees list all seems to work out just fine, and as taxation doesn't play its uh delet what is this word doesn't play its deleterious part, these inter vivos trusts just get bigger and bigger, and all this is done without professional help. So inter vivos trust, I would have to guess that that means the living trust, right? And I'm very happy that this is just confirming things that I'm doing, because I recorded a trust, and it is a domestic trust, private, because I didn't give much information, but it is also considered from somebody who told me it's an inter vivos trust. Anyway, let me get back to it. Therefore, as we have shown, ownership of assets. Wait a minute. Am I? Hold on. Where did I go? Hold on. Where did I go?
Top of page 18.
Okay, here. Page 18, right? Here at later, we will again remind you that when it comes to setting up trust, it is now held by the federal courts that using an attorney to create a trust is the same as if you did it yourself, thus voiding any possible advantages to the claim of third-party creations. Failure to heed this advice will definitely flaw your planning and will result in the IRS claiming that you did not irrevocably transfer assets to a truly third party, which will make your trust subject to the grantor trust rules under section 670680. I believe that's the Internal Revenue Code, IRC. Also, you cannot appoint yourself, your spouse, lawyer, or close relatives as trustee if one of these persons is the creator, as you must appoint a stranger, someone who is in adversarial position to you. In order to allow you to be the trustee from your trust, we cover this area under the section dealing with sham, the revisions of interest. So I'm thinking and saying that how if an attorney helps you with with creating a trust, and you appoint yourself as trustee, it kind of doesn't make sense, because then you should be able to be competent enough. If you want to be trustee of a trust, you should be competent enough to create a trust, I believe. So if you get an attorney, It's fine, but there's some complications, there's some issues apparently. By utilizing the suggestions in this manual, you will drastically limit the income of CPAs and attorneys. This is good for you. Professionals will still have plenty to do. Remember that if laws are deliberately passed to make doing business and assets protection more difficult for those who do not know these complex ways, then it is obvious that the lawyers and accountants will move in and profit from these laws using the paths of least resistance and using inferior trusts, grantor type trusts. As far as assets are concerned, they have become the objects of government seizure, private lawsuits, marital disputes, testamentary entanglements, malpractice suits, and in general subject to defense from all quarters. These cost money. This costs money. In this kind of environment, it is natural for the ranks of attorneys to swell and prosper. Even such modifying suggestions as having the losing party to a lawsuit pay the cost of the prevailing party's lawyer under, understandably is frowned upon by most leading trial lawyers. That would make people think very seriously about the consequences of frivolous litigation and using that type of lawyer. Therefore, as we have shown, ownership of assets has become a bad thing. This is not funny at all. Unfortunately, it is sad but true. You, as the owner of assets, have become the potential target for everybody. You carry the fruits of your work with you into litigations, and that exposure is totally unnecessary. If you did not own anything, any judgments against you would result in zero results at law. You probably wouldn't even be sued, and you wouldn't even need to hire a lawyer to defend you. We are assuming that the reader is just a person and would compensate those he may injure as he feels they have been monetarily wronged. But such a decision would not be dependent upon the amount that a liberal jury, rarely selected from your peers, might decree. So basically, right here is saying that you are the owner of assets, but it makes you a potential target. So if you pass it on to the trust is the owner. Now you're not liable, right? So it's very good stuff. More problems. Okay. What is the solution? For illustration purposes, say you now own a very expensive piece of property and you sell it for fair market value. And the new owner is a truly uncontrolled third party. You may be appointed the manager of the property if the new owner hires you as such. That particular property cannot be taken with you into a lawsuit to satisfy any claims against your actions. But you're probably thinking, what about the proceeds from the sale, which are yours? We will answer this later as we progress into the important areas of installment sale and accounts receivable financing. Okay. Most of the advice you will get from professionals will be quite naturally opposed to the methods you will learn here, basically because they quickly realize that they can't legally get a piece of you in your planning and operations. What's happening here? You want to know what's going on here? Sorry about that. Okay, here we go. Let me read it again. Most of the advice you will get from professionals will be quite naturally opposed to the methods you will learn here. Basically because they quickly realize that they can't legally get a piece of you in your planning and operations while you're alive. And worst of all, They will be financially frustrated after you die by eliminating probate court executors and administrators. One client, acting as trustee for the U.S. Citus Trust, was told by a trial lawyer that trusts were not a legal entity as recognized by the state, and he had better change to either a sole proprietorship or a corporation if he wanted his firm to represent him in a lawsuit against another party. Such bizarre legal malpractice is rampant in the US. A few of us advised this particular client that over half the banks in the state were lawfully acting as trustees while occasionally defending and pursuing litigations for the trust in the state's court, and that for many years before there was even the thought of corporations, there existed trusts. Unfortunately, there is, as they say, a lot of this going around. This manual will give you a firm foundation in the use of trust. Later, your faith will not be shaken if you now get a working grasp of trust and the proper way to sell your accounts receivables. That's what we want to do. We want to sell our account receivables. That's what I'm going to do next. Blame politicians. It is neither the legal nor the accountancy professions that are to blame for all of this. There have been many jokes about lawyers and accountants over the years, but try to look beyond to the actual and continuing creation of the laws that led to the expense factors which tend to make us lose sight of the real problem. But professionals are not the real problem. The professionals have, as could be predicted, naturally gravitated into the compliance of these laws for profit. Why some trusts fail. Reflecting back from 1930s to today, the three major reasons for trust failure of what could very well be the single best tool for the entrepreneur insofar as estates and income tax savings are concerned are: 1. Failure to report income on trust returns; 2. Creating false expenses; and 3. Ruining the truly third party requirements by using an attorney to create a trust and or to retain incidents of management and control for themselves by using an attorney. All these flaws are avoided by sticking to the formation and management that you are discovering in this manual. For an overview of international economic interplay, we cannot think that the events which have led up to the present laws, regulations, and governmental agencies is accidental. Indeed, it must be planned. The laws used by extremely powerful group of and companies to limit competition force all those who do not know how to get through the minefields that have been created to pay many types of taxes, and they, the knowledgeable, avoid. Yes, most of us are playing against a stacked deck. This manual was written to show everybody how to stop running into these pre-planned mines and going along with the major players' tactics. When you start to change your method of asset protections and business, it won't take long to benefit from the powerful compounding effects of untaxed growth. Yeah, man. How to do it yourself and create your own trust. Keys. Life of trust. Insofar as any reversionary interest is concerned, must be longer than 10 years. Okay, so a life of trust, insofar as any reversionary interest is concerned, must be longer than 10 years. Okay. Of the three parties to a trust, none save the trustee can have any disposition powers, rights over beneficial interests. Example, right to accumulate, declare, receive distributions, change management, or to set investments, policies, selections. Trustees must be third party to the creator. Okay. No special privilege can be granted to nor taken by the creator. Beneficiaries must have a sole liquidation rights. They may not also be the creator. Creator must not be able to revoke the trust. Creator must not be empowered to distribute income to himself or to attorney or to wife. Trust must be formed under contract law, not any statute trust law. Trust life should be renewable after it exceeds the minimum of 10 years period. Thus, it can operate indefinitely. Transfers by sale only of assets must not contain any reversionary interest for the seller. Any retention is considered tax evasion. Trustee must be third party, operating at arm's length. IRS does not allow close relatives, lawyers, or accountants. If such a party is placed in control, the taxes are not paid, then the IRS will claim tax evasion. Almost all of the foreign trusts we have been asked to examine fall into this dangerous category as they are formed managed by the client's lawyers. Best to set up with only non-US residents as creator and beneficiary. Keep the setup as a US situs trust with the US trustee, US real estate holdings. Foreign trust beneficiaries should have a perpetually chartered corporate trustee for indefinite operations. Utilize the US Canadian tax treaty to avoid or drastically reduce local, state, and US taxes. Wow, so as it says, to utilize a tax treaty between the US and Canada to reduce the local, state, and US taxes. And be as of 1994, 50% capital gains tax instituted in Canada. Set up for directing by request gifts to third parties from offshore entities who qualify under IRC section 2501A subsection A2 IRC. Such gifts are neither reportable, includable, nor taxable to their recipients in the US or offshore. Gifts can be made to you gifts can be made to your second US trust. Don't ask for a gift to you if you are the seller of an AR, accounts receivable. Your cost to set up this operation would consist of enabling the documents as given in this manual. Just fill out the blanks and obtain the parties to your US trust and the foreign beneficiary. You're in business. Let me see where we are right now. All right. So we are existing companies. I'm just going to probably read for about probably a little 15 minutes more, guys, and then we'll probably just continue next week. Existing companies. For a practical standpoint, the larger in size a corporation is, the more awkward it is eventually to halt operations and convert over to the trust form of doing business. That is not to say it is impossible for the largest of corporations to switch. Your stock holdings can be exchanged or sold into your trust. As the new owner, the trust can exercise all the rights that you had before the transfer through you, acting as trustee for the trust. This will get your stock and bond holdings out of your estate. Nice. Transfers of intangibles to the trust, to a trust. Cash is an intangible asset. In order to get it under the the aegis of the trust, you should lend it to the trust and take back a note to yourself by using a copy of the exact note that you will find in the forms chapter. Again, all these forms are being used with confidence since they are substantially unchanged since 1929. Books could well be devoted to each form that you will find here in this manual. We will spare you the treaties in order to get the basic ideas across to you. If we can accomplish just this, we feel that we will have excelled. Tax haven concept. Where, although there are a large number of jurisdictions in the world that one may call tax havens, common sense dictates that they should be located where true trusts are frequently used. Serious problems arise from the use of the, that's a big word right there, of that's another big word, Liechtenstein of Switzerland, because the meaning of a trust is changed. Similar dangers lie in Dutch law, Netherlands anthems. US court cases practically emasculate these agreements. The selection process should further insight that the English language be the mother tongue along with UK English common law. Easy access to good and reliable communications, proximity to the US, bank secrecy laws, freely convertible currency, US bank correspondence, and ease of daily air links should be given serious consideration. The Cayman Islands enjoys all the above good points with total income tax freedom for non-residents, i.e. you. So they're recommending the Cayman Islands as a trust haven. The variety of the variety of tax haven arrangements are vast. The US is ironically the best tax haven in the world for foreigners. This is why the successful people are using a tax haven foreign trust. You can reinvest in the US tax free. This is a golden circle. Tax havens have been around for centuries in one form or another, providing secrecy and little or no income tax. The CIA still uses these secret operational trusts and foreign corporations in their international dealings. The old OSS used foreign trusts with their secret provisions during World War II. Money still pays the way for espionage. And when it comes to handling many large financial transactions, both in and out of the US, the monetary convulsions, which require unique and absolute anonymity, necessitates foreign trusts. Let me see. I think we're gonna call it right here. We're gonna start off next week on account receivables. It's already, let me see, we have been on here for an hour and a half. And unfortunately I gotta go do something in a little while. So yes, guys, we're gonna call it for today. That first part. See, I read this part already. I read this already, and it actually goes into some very good forms, and it goes into explaining how we can um, appoint these places like in the Cayman Islands as successor trustees, and how we can, through the trust or as representing the trust, can donate or sell the accounts receivables to these places in the Cayman Islands so that it can come back, so the Cayman Islands can then send it to another trust, which is also where we can be a beneficiary of, so it's a very cool little trick that they have. But anyway, guys, I just want to thank you guys for joining in today. Thank you so much, Seth, Sabea, Lorna,
Thank you,
Ernesto.
brother.
You
Yes,
guys,
yeah.
thank you. And I know this was very technical. It was very, very technical. It's kind of hard. A lot of the terminologies which was used right now is kind of a little bit, foreign for us to understand off the back. So whenever you guys want, you guys can go over it again. But we're gonna go over account receivables next week, and it's gonna get a little bit more technical in account receivables. But it'll give us account receivables are basically assets, right? The assets that are coming in. So anyway, guys, before I go, I wanted to just uh, expand a little bit on income. I'm gonna talk about income, right? Just really quick about income and what my thoughts are on that, and maybe we can discuss this too. But um, you know how they say that you have to report the income, right? So who's saying that you have to report the income? Well, what's the definition of income? The definition of income is monies that come into a trust. Okay. So are they talking about the money coming into the trust, which is the public trust, or the money coming into your private trust? Which one do you have to report? Well, I would assume that we have to report what goes into the private trust. Because if we are from sorry, I would assume that we have to report what goes into a public trust, public trust.
Right.
Because if we have a private trust and out of our private trust, we take out an asset, something of value, and we put it into the public trust, or we donate it, or we sell it or we transfer it to the public trust. Now they have received an income. They have received an income, and by means of an acquisition, they have acquired trust property, private trust property, like a bill of exchange or a promissory note, and they have received it into the public trust. So now they have an income. So if we report a 1099A, which is an acquisition, we report the OID, essentially we're reporting the income that has come into the public trust, but it's the income that which was received by the individual. Let's say like for example, let's say we want to I don't know, discharge a debt, and we provide to the electrical company a bill of exchange, right? Well, that bill of exchange came from the private trust, and it went to a public creditor or a public debtor, whichever. It went to the utility company. So they received an income. They received an income, but it was through a trust property and through an acquisition. So I am I'm looking at it in the way that if we report these 1099s, if we report these 10 OIDs, and we send in the voucher, and we do the whole payment process, the performance process, that did create an income. It says that they got an income. Now they are forced to now have to pay the taxes on that. So it's avoided on our part. We don't have to pay any taxes. And why should we have to report what the income in is in our trust? Our trust is private. So that's where I'm coming from. Do you guys get that? Do you guys understand that?
Yes.
Yeah.
Yeah. Perfect. Perfect. Yeah. So that's why I think that our goal, once we have set up our trust, is to now learn how to manage it. And one of those essential parts of management is going to be the tax forms, reporting those things and getting those things back. Because what we're essentially doing in those 1099s, we're saying, hey, we're reporting an acquisition, we are the lenders, they're the borrowers. Okay, so if we lend something, we should get that back, or at least the interest, but we should get that back. So by reporting all that property, I think then what we're doing with these vouchers and 1040s is that we are essentially making sure that the income is reported, and that the credits go to where it should go, right? It should be returned back. So then, and again, I think that's when we should have a little account set up, a bank account set up that will be receiving all of those different returns, you know. And I think after this, we read this trust, secret trusting, we're probably going to get into something more on that, you know. But yeah, I wanted to bring that up to you guys. I think that's very important. It's very interesting too to to be learning about this whole tax issue now. You know, seems like that's the way tax department collects interest for the creditors, but they call it tax. They don't call it interest. But what they're doing is collecting interest for creditors, for private creditors, and that's us. So basically, they work for us, but we got to give them something, right? So if we give them the rights to collect the interest, right, by a transfer and assignment, and they accept it, well, they've accepted the conditions, they've accepted the contract. We have, we have an agreement. So then they go collect the interest, the tax, and bring us back the credits, right? And then let them keep the tax, let them keep the interest. I mean, we are the creditors. We can give them credit all day because we can manufacture credit all day, you know. So yeah, I just wanted to mention that. Thought it was important to mention. You guys wanted to talk about anything else before we call it the night? Anything about what we read or what was read?
Well, so basically, we're creating new money every time we go out and purchase something.
Yes,
Yes.
it sure seems that way. Yeah. Yeah. We're creating money on demand. Like when we swipe our card, a negotiable instrument is being printed out by that machine. It's just that since the laws have progressed, they no longer need our signature. It's implied that we have already consented for them to just go ahead and, you know,
Well, that's
accept.
called the electronic signature.
The
Yeah.
When you swipe
EFT.
your card, yep.
Yep. Yep. Yep. Yep. Yep. And I think that's what me and Lerna were talking about, is that I think it will be best for us to go to our banks and say, hey, you know what? I want to make sure that every transaction is authenticated and certified by us, and it require a signature just for security reasons. I would like that, and I think I think they should be able to accommodate that upon request, and then that way, when we sign it, we can sign it through special endorsement, without recourse, paid to the order of the all caps by our Christian name or regular name as agent. And that automatically, they will have to use that specific piece of paper as their form of credit and not touch the credit that is in the accounts. So the credit in the account. So if our bank account has, let's say, $1,000, let's say it says 1,000 credits, and we go and we swipe our card for 500. Well, if we special endorse that, they should, that instrument that was printed out from the machine, well, we do it without recourse, paid to the order of the all caps by such and such agent, then they need to use that particular piece of paper as the source of credit and not touch the 500 or the 1,000 that we have in the account. So that 1,000 to stay there, and they need to use that, and then we go and then we report it, to the IRS,
Mm-hmm.
and I guess we can claim that instrument.
Hey, Chen, I have a question on
Mhm.
the what we receive in the banks, for instance, a direct deposit. It doesn't matter like what you're explaining. Does that matter? Like if it's wages, income, or compensation, it doesn't matter like in what category it falls into. It's the same thing always, no matter what.
I'm sorry, I didn't understand that. Like if you get like a deposit, it doesn't matter if
No,
it's
like
wages or whatever.
what you're explaining about like how it works, right? Like you're like, oh, if you have such and such amount and you like have do the transactions, it doesn't matter. Like the transaction is gonna be coming out from an account, a bank account. but it doesn't matter like if it's wages or compensation, as long as it's just the promissory notes in the debit account, or that has nothing to do
Yeah.
with it.
Well, the thing is that every transaction we do is a brand spanking new transaction, whatever the transaction is. Either a promise to pay is being manufactured or an order to pay in
Got
every
it.
transaction. Yeah, it doesn't matter. We're actually manufacturing new money or new credits at all time, because think about it like this: we are in like a system that nobody has money. Everybody's broke. Everybody's broke, and you can only operate if you get some tokens that have some credit in it, or if you get some credit. But in order to get credit, you have to give them something, right? You got to give them something. So if you give them a promise that you will pay, then they accept that, and then they say, okay, well, I'll give you some credit. And once you deplete that, then you now have to charge it back up. It's like a battery going on empty. If you charge the battery to full capacity, now your account is full of credits. Now you use that, it's done. Now you got to charge it back up, right? So that's one way of looking at charges. But at the same time, every transaction we do is basically creating a new instrument, new credit, because we're actually manufacturing new credits at all time. Because there is no old credits that we can use, because the system is designed to just always create new credits. The credits that are in an account because of an asset that was received there, the bank is holding it as custodian. And when they take those assets and they reinvest them in secondary marketable securities such as debentures and such, now they become like trustees. But of the account, they basically are just custodians. That's how they should be. Now, when we go in there, let's say we have a trust set up, a domestic trust set up, and now we're trustees and we have all rights, titles, and interests to all the accounts, and we can benefit all the trust can benefit all it. And we go into the bank and we're supposed to now make sure that it is acknowledged by the bank, and the bank understands, and we make it clear that we are now the trustees of all assets. That we only the trust can dictate how the assets of those accounts are going to be managed, invested, sold, transferred, whatever. And what they're going to get is just a little piece of the pie. They're going to get the fees. We're going to give them the fees. We're going to give them the interest, and so on and so forth. And then they basically work for us. But at the same time, they don't decide it for us. We decide it. So that's when we can now come in and say, hey, here's a bill of exchange. I'd like you to utilize this bill of exchange, release the credits, and then send it over to this other account over here to discharge the obligation. Now, technically, that's how it's supposed to work too, as far as I understand. But because they're not operating like that, they don't do that, then we have to make sure we have to go through the tax department, because those banks are supposed to be helping us out too. But like this trust document was saying, a lot of these banks get caught up in they invest in long-term deals, and then when we bring this up, they're like, oh shit, we're already caught in a bind. And then they don't want to basically give us what we demand, because it kind of puts them in a situation where they are already invested in the assets somewhere else, and now they gotta
Yeah, they securitize the note.
Mm-hmm.
Sold it.
Right. And if they didn't have the authority to do so in the first place, that would put them in a jam. So I think a lot of them, like how Brandon Williams says, they would prefer to die than to admit it. They would prefer to die. Yeah. But yeah, it's very interesting how all this works, how this credit system works. The more you learn, the more you know. Well, yes, guys. Well, I guess this is it. Thanks again, everybody. Thanks again, and we'll do
Thank
it
you,
next
Chandon,
week.
for your time, bro. We appreciate all this time.
Thank you, Chandon. Amazing.
Thank you, brother.
Yeah, thank you, of
You
course.
too. Thank you, guys. I appreciate it. I mean, it's kind of. I wish I could do it. I'm sorry about last week. It's just so much things. It gets a little busy, and I try, but I'm thankful that you guys still show up, and I'm grateful that I'm able to share this with you. And thanks a lot too for you guys. I really appreciate you guys a lot. And little by
We
little,
appreciate.
we're gonna be getting remedies. All of us are gonna be getting remedies, little by little. We're
Yes,
not
yes.
Yes, indeed.
Let's do
Yeah,
that.
that's what we're looking for.
little by little. We're gonna be getting. You'll see it, man. Watch, watch. We're doing it. This is just our learning phase. We're crawling before we can walk and run and dance, right? So,
Yeah, that's
The
true, man.
so
snowball
we'll be
effect.
dancing.
The snowball effect.
That is
Yeah,
true.
man. And Seth, he's going through some things right now at court, and and Seth seems to be grasping it very, very good more and more every time I talk to Seth. He's like, wow, he's really wowing me and how much he's grasping. So that's great job, Seth.
Yep.
And I really
Thank you,
hope that
brother.
we can. Yeah, definitely, bro, definitely. And I really hope that these classes and our constant conversations they come out with some beautiful fruits. And looking forward to hearing something positive in that court case that's coming up.
Well, you definitely dig the hole and plant the seeds, my man, and add the water. So I appreciate it.
No problem,
Everything.
man. No problem. You're
Peace,
doing
love, and
great, man.
prosperity.
You're
Great.
Yes.
doing great, man.
I
Love, peace
thank
and
you,
love
brother,
to
for
all you guys.
everything.
Oh man,
And,
no
and many
problem, man. No
blessings to
problem.
all.
Yes, sir. Yes, sir. All right, guys. Well, you have a good night, blessed night. I love you guys.
Are
I'll see
we
you
uh
guys
are we
again.
planning on next Friday,
Yeah,
Shannon?
yeah, yeah.
Okay,
Let's do it. Let's do it.
beautiful.
Fridays works better.
I'm sure we'll
Yep.
talk
Perfect.
before then, but enjoy your
Oh yeah.
weekend, everyone.
You
Or I
too.
should say your week strong.
You're week strong, right? You're not weak. You're not weak on the weekend.
Enjoy your week,
Yes.
Sean. Yeah, I like that. I like that.
They say
To
you
be
get
more
weaker on the
careful with
weekend, right?
words.
Week strong. You're right.
That's what they say. Yeah, yeah. We go. We strong. We strong. We strong. You're right. All right, man. I'll see you guys. Peace and
All right,
love.
guys. Stay safe.
All right, many blessings.
Same here.
Many blessings. Peace. Peace.